Angela Davis has done a lot of great webinars for us in the past, and she has put a lot of work and effort into not only writing a summary document about this new legislation, but also done this presentation. So without further ado, you can all applaud in your at your desks and your offices and at home. And here's Angela Davis.
Well, good afternoon, everyone. Thank you for tuning in, and it's a pleasure to be with you this afternoon, but I guess it's for somber purposes, and that's the big elephant in the room, right? Is the reason that we're here talking about this is because we're in this pandemic health crisis, and we're here to talk about these new federal laws that impact how we go about our businesses and how we take care of our employees and our workplaces on a day-to-day basis in our new normal. I would be remiss not to start by saying I hope each and every one of you are well. So many of you I talk to around the state all the time, if nothing else by email, if not by phone or in person. And I truly, truly wish you very well. I hope your families are well, that your workplace family is well, and that we all stay well. And as people keep saying, we're in it together, and I feel that way with these legal issues as well. So as we go through this today, please know that I'm here to answer questions during this webinar, and then after that as well, I'll make myself available because I know it's all coming really fast and furious, and I can appreciate the panic that can be causing, because I certainly can appreciate the panic that we felt we're under recently and just trying to grapple with all of these new issues. So with that as a backdrop, let me tell you how I've planned to spend our time together today. I've put together a very simple PowerPoint that I'm just going to walk through that gives you the skeleton and the framework of the two primary federal acts that we are going to be talking about today. First, we're starting with the Emergency Family Medical Leave Act, and then we'll also talk about the Emergency Paid Sick Leave Act, two new federal laws adopted by Congress, signed by the President in just the last week and a half. And they are effective today, April 1st. And that's not an April Fool's joke, unfortunately. By calculations in the statute and some early literature you may have seen, there was an April 2nd date, but the Department of Labor, for whatever reason, has adopted an April 1st effective date. So we're going with that since they are the interpretive agency, and we are approaching this as if it's effective as of today's date. At the end, I'm going to wrap up with just some of the other issues that are out there, touch a little bit on the Georgia Department of Labor emergency rule on unemployment compensation and how those options for employees and for employers kind of circle into some of these issues. And then also, just to the extent you may have any questions as to how dealing with these issues in the workplace might implicate the Americans with Disabilities Act, if you're talking about health-based issues, we'll talk about that briefly as well. So without further ado, let's just jump right in. And I'm used to, okay, there we go, working this in a little bit different way. I'm in my office and Dan's in a different place, and I'm used to having him right here in front of me helping me. So please bear with me in any technical difficulties I may have today. So again, these are the two main federal laws we're going to talk about, EFMLA and EPSLA. They start today, and they are effective only through the end of the year. Jumping off first on this Emergency Family and Medical Leave Act. So as all of you know, as HR professionals, the Family Medical Leave Act is still in existence as it's always been. This is an amendment to it that's created this expanded right. But one of the things it did for purposes of this expanded right only, so it hasn't upset the apple cart with all the other aspects of FMLA, all of that's intact just like you've always applied it. So your handbook policies are good, your forms are good, everything's good on anything to do with standard FMLA. This just amended that act to add this new basic qualifying reason. But to do that, they changed some definitions. And one of the definitions they changed is who is a covered employee and covered employer. First of all, for an employee, if you've been employed at least 30 days prior to the date that you wish to go out on leave, then you are indeed covered under EFMLA. As you know, that's very different than what we're used to. We're used to seeing the necessary 12 months, 1,250 hours, and this requirement of 50 employees at a particular place. All of that goes by the wayside when it comes to this particular new issue. So if you have an employee who's been with you for 30 days, that employee is going to be covered. Likewise, if you're a public agency, a local government, which all of you are, your county, your city, any of you are going to be covered by this act. You will notice that there's some language in the act if you've read anything about it, and particularly if you hear anyone speaking about this from a private business standpoint, you'll see a reference to fewer than 500 employees. And so we've gotten that question a lot as to whether the Emergency Family Leave Act applies to those counties or cities with more than 500 employees. And the answer is yes, it does. It does apply to all local governments. I will tell you that that answer is not as simple as it might seem, and certainly not as simple as it could have been had the statute been very clear. But we believe that that's the appropriate conclusion. And then DOL, the Department of Labor, issued some interpretive guidance late on Friday and then late on Sunday that made pretty clear that it applies to all local governments, and that fewer than 500 employees applies simply to those private employers. Federal employees in some extents are exempted. So you will see some reference to certain local governments or certain public employers, but consider yourselves covered, and any employee that has been with you at least for 30 days. Now, importantly, there are exemptions, 2 exemptions available under EFMLA, and that's for a healthcare provider, which probably doesn't apply to most of you or any of us as governments, but emergency responders is the other potential exemption, and that certainly is something that each of you would have to contend with. So the Department of Labor now has issued guidance. This is not in the act itself. The act itself does not define emergency responder, so we were kind of grappling with that for a few days, but the Department of Labor now has defined emergency responder as an employee who is necessary for the provision of transport, care, health care, comfort, and nutrition of such patients, and whose services or whose services are otherwise needed to limit the spread of COVID-19. The Department of Labor guidance goes on to include this additional aspect of the definition, which I won't read all of that to you. It'll be in your materials, and as Dan mentioned, we're going to make this available, the PowerPoint, as well as some other instructional materials that summarizes these acts. So don't feel like you have to try to write all this down, but basically it's what you would expect. It's your sheriff and police, correctional institutional personnel, firefighters, EMS, EMT, paramedics. Some that might not have been as obvious that are included in this definition include 911 operators, public works personnel, persons with skills or training and operating specialized equipment or other skills needed to provide aid. So those are some items and positions that you might not have thought of before. Interestingly, this definition is in large part borrowed from the Homeland Security Act, and it's quite broad. And so it gives you an opportunity to exempt from coverage any of these designated emergency responders. And so by exempt means if you make the determination that certain emergency responders are going to be exempt, then they would not be afforded the rights under this particular federal provision. We're going to talk in a minute about the Emergency Paid Sick Leave Act. That also has an exemption provision as well. You could make a decision to do one or the other and not both, and we will talk about that some more. But importantly, you don't have to exempt any emergency responders. You could exempt some on this list and not others, depending on how you believe you need people in place in time of emergency, because that's what it comes down to. This exemption is available based upon the public policy understanding and reality that if everyone goes on leave, we won't have these important emergency response providers who are available to provide these essential public services. And that's why this exemption is available to you to make those decisions. In terms of when you decide, and I'm going to go back just one second. Let me make a couple more comments about this, because I'm sure we may have some questions, and I'm happy to get to those too. But I will tell you that the exemption, as I said, is available not only under the Family Medical Leave Act, but also under the Emergency Paid Sick Leave Act. I have some clients that have been trying to decide what to do. They want to do right, obviously, by their emergency services personnel and want to give them the opportunity to protect themselves and their families, and certainly to protect the workplace if they may be sick or symptomatic or need to quarantine. But there's also that corresponding reality of, again, needing to ensure that public essential services are provided. So some are considering doing a partial exemption, or perhaps saying, okay, an emergency responder is exempt from Emergency Family Medical Leave Act, which we'll discuss in more detail in a moment, but that's for the sole purpose of staying home to care for a school-aged child or a child who's out of daycare because the child care facility is closed. But we're going to allow them to stay in coverage for purposes of this emergency paid sick leave in the case of being sick or symptomatic or under order of quarantine. So please know that there's some flexibility here, that you could declare a partial exemption, you could declare no exemptions, you could exempt them from all. But that's something for you to think about depending on how your particular government runs and what your needs are. It's important to note that there's no deadline under either of these federal acts as to when you must declare an exemption. So some have asked me, well, can we take a wait and see approach? You know, we don't necessarily have to exempt if we end up with maybe 1 or 2 of our sheriff's officers who need to be out. But if 35 or 50 of them need leave, then it's a different story. So this wait and see approach, is that permissible? I've been asked that question. Well, there's nothing in the act that would prohibit that, but I will caution you against that simply for this reason. Just like any other benefit or employee decision that we make, we need to be consistent. So certainly it could be explainable if you have 1 and then all of a sudden you have 50, that you have decimated your department in ability to provide that essential public service. But we need to be real careful that we make decisions that are not appearing at least to be discriminatory. So if you make a decision to allow some people to take the leave and then all of a sudden you decide, okay, now it's too much, when you make that decision, that group of people who then are denied, you know, could conceivably be concerned that that's been made in a discriminatory manner. I know that wouldn't be the intent, but that's something you'd have to think about if you don't declare your intent and purpose on the front end. So I would suggest, and I think my best recommendation for you would be to make a decision based on what you know with respect to your workforce now, and decide whether you're going to exempt, and if so, what positions and to what extent. All right, moving on. The qualifying reason.
I have a question here.
Oh, hey, yeah.
To clarify, must have worked for an agency for 30 days, but no minimum hours?
That's a good question. That's all that the act says, is 30 days prior to the designated leave. And there's some guidance that talks about, well, how do you know about 30 days and it's being on the payroll? So I think if the employee has been, and particularly this could be in play if it's a part-time employee, maybe they haven't had a ton of hours. But if they've been on your payroll for 30 days, then they're eligible. You will see with this, and then with the Paid Sick Leave Act as well, everything I think underlying these 2 new federal acts is entirely pro-employee and an opportunity to give employees the most relief that they can, to have an opportunity to continue some compensation, to continue in their jobs, but also to stay home as needed. So I think, you know, in some of these issues where it's not entirely clear, my best recommendation has been to be liberal in applying them on behalf of your employees, because I think that's the clear intent of Congress on these policies. And unless and until we get more specific direction from the Department of Labor, if they've been on payroll 30 days, I would consider them to be eligible. So now going to the qualifying reason, under the Family Medical Leave Act, there's only one reason, and this has produced some confusion for people. So this is clear, one reason and one reason only, and that is to allow an employee who is unable to work or telework to care for the employee's child under 18 years of age if the child's school or place of care is closed, or if the child care provider is unavailable due to the public health emergency. So with that in mind, you know, this could very well apply to your almost whole workforce. I've had some clients tell me that, oh my gosh, almost everybody who works for me has a child who's home because the school has closed down. So there's some questions that you know, need to think about. not the least of which is the big bold-faced type here, is if they're unable to work or telework. So the teleworking decision is something that really counties have to make. There's some positions that can produce, quality and effective and valuable work for the county or the city or the government entity at home, and teleworking is a real opportunity and possibility. There's some positions where that's just not feasible. So first, the county's going to have to make the decision. Can I offer you an opportunity to telework if you tell me that you need to have some time home to care for this child? But then the second piece of that is the employee also has to make a decision whether they are able to come to work or believe that they're unable to telework. So if they take the position that, no, I have this 7-year-old at home, I'm responsible for all of their homeschool obligations, and there's no way that I can spend time during my day teleworking, and I need to be an FMLA leave, then that's them making the decision that they're unable to telework. Now, of course, what my suggestion here is again, I think we have a federal law that is intended to benefit employees. It's intended to be applied fairly liberally. That's what all the guidance documents say coming out of the Department of Labor and the EEOC and other places, is flexibility by the employer. But I don't think that means you can't have a conversation, because you could ask them, well, is there a chance you could telework for a certain period of time during the day? Or is there a chance that your spouse, if that's an opportunity, could care for the child half the day and you could telework half the day? Or even could you come in half the day or come in 3 days a week and your spouse could carry the other 2? There's a lot of opportunities here. And there is an opportunity for intermittent leave for purposes of this family medical leave that I'll talk about a little bit more as well. And it's kind of hard to talk about each of these issues in a vacuum, because it just kind of spirals into how they all interrelate. But there are a lot of options here. So if an employee says, I've got a child at home, that shouldn't automatically mean for them or for you that, okay, oh gosh, that person can't work. The person probably wants to work because they want to keep getting their paycheck. So that's where you need to engage in an interactive process to determine at what point the person isn't really able to come, can't come at all, or whether teleworking or some kind of intermittent leave is available if you're willing to work with the employee in that way. Now, how long does this leave last? Well, it mirrors the traditional Family Medical Leave Act in that it's providing for 12 weeks of protected leave. Now, it's 12 weeks total, so this includes any traditional FMLA. So if you have an employee within the 12-month period who has been out, maybe they've had some kind of surgery and they've been out for 6 months already. I'm sorry, 6 weeks. Then they only have 6 weeks available for this Emergency Family and Medical Leave Act. It's not an additional bank of time. It's just an additional reason for which they can utilize what's been granted under the act already, and that's just this 12 weeks. So just please understand that it's not a 12 plus 12. We have to count up to 12. And if they take the emergency family and medical leave and take the entire 12 weeks, then that means they're out of FMLA. If they come back when things return to normal and they need a surgery or some other serious medical condition that they need to be out of work within the 12-month period, then they're going to be out of leave. So that is something as well you may want to make sure your employees understand. If they come to you and say, oh, I want to take this 12 weeks to stay at home with my child, it may sound like it's a great extra added on benefit, and in some ways it is, but they do need to understand that it's not an extra 12-week gift that they're getting, but indeed it's going to count against the 12 weeks that they could potentially need for some other serious health condition or otherwise.
Angela,
now, yes.
I got a couple questions here.
Okay.
If school stays closed through the end of the school year, it would be the same as a regular school year. So would the child care not be applicable during the regular summer off season?
That's a great question. The statute reads in terms of the school being closed or the child care being unavailable. And I've had a lot of people ask me that. Well, what do people do in the summer? Why is this changing the entire, landscape of how we deal with employees who have children? Because obviously they still have them in the summertime, but we don't give them these times off. So I think, the purpose of the act is that these schools that are closed but continuing to impose these obligations, that it really is like another job for them at home to continue to keep up with the schoolwork, particularly for younger children where they have to assist them with the technology and with the assignments. And that is very distinctive from summertime. In my opinion, once summer hits, it should be different and it should not be available. But to be perfectly honest, that has not been addressed. And the Department of Labor has not weighed in on that with any of their guidance documents that I have seen as late as this weekend, which is the last thing that they've issued. So I think as this crisis continues to unfold, and if we get to that point, then I think indeed that's a question that's going to need to seriously be considered. Well, and also whether they've used their 12 weeks by that time. I guess if people go out now, conceivably they could use about 8 weeks before summertime would hit. And in my opinion, based upon the way the act reads, it says if school is closed, well, school's closed in the summer, so a strict reading would suggest maybe it continues, but the policy-based reason would suggest that it shouldn't continue. So I hate to not give you a clear answer on that. I think that's something we're going to have to wait and see what guidance we get from the Department of Labor, who's the enforcing agency, as we move forward. There's just so many questions right now. Of course, the hopes are that schools will reopen and that won't be a factor. But importantly, this act is in place from now until the end of the year, which does beg that question. If it's in place all the way through the end of the year, could they just call it up for purposes of summertime? But again, I don't think that's been addressed yet, and I think that's something that we'll still have to keep an eye on. And I'll certainly be able to offer you and happy to offer you any updated guidance if we see anything new coming out on that point. So was there another
couple more questions?
Yeah.
One, can we legally request proof of eligible child and their age, birth certificate, etc.?
Okay. Yes. Let me go back for just a second. I'm going to answer that question. Let me go back to the first question. I was just, while we were talking about it, pulling the actual statute to see what it says about the reason justifying the Family Medical Leave Act. So it provides that the employee who can't work or telework is home to care for the employee's child if the child's school or place of care is closed or the child care provider is unavailable due to a public health emergency. So as I read that definition, I'm going to backtrack and I'm going to correct myself. I think because the statute does connect up to say that it should be closed due to a public health emergency, I had to pull that exact language to feel comfortable with saying that. But I think then once it's closed because it's summer and it's no longer due to the public health emergency, that at that point in time, this leave would not be available. Of course, it does beg the question as to why the leave provision would extend all the way out until December 31st. But I think that qualifying phrase at the end of the statute that says due to a, quote, public health emergency, that would mean, again, that closure for summer would not trigger availability for this leave. So sorry to backtrack, but once I got that language in front of me, I wanted to clarify that. Okay, so the next question was, could we ask for a birth certificate or some kind of proof of the child's existence or school closures? That's a great question. Yes, what has been made clear through the Department of Labor in their guidance materials is that we can seek certification and clarification on these issues just like we would normally do with Family Medical Leave Act requests. So my recommendation would be to create a form that has them certify as to the identity of the child. You could ask for a birth certificate. You could also ask in that request or in that form for them to identify the school that's closed or the child care provider that's closed. At this point, in terms of any school-age child, we know that the governor's order is such that the schools for public schools are closed through April 30th. So I don't know that we would need to ask for anything in addition for a public school student at this point, but I do believe that you can ask for those certification materials so that you are ensuring that you are applying the rules fairly and consistently and correctly, with them proving to you that not only do they have a child, that the child is 18 and under, that there's a school closure. If it's a private school, that could be more questionable. and also if it's a child care provider, that child care provider is indeed closed, and again, closed due to public health emergency. So I hope, did that get all those questions?
Well, we got 3 more while you were answering
Okay.
those, so
Okay.
which is good.
Great.
What if there's child care available in one case, the normal child care provider isn't closed, but the employee no longer feels comfortable using them? Do we still have to extend FMLA in this case?
Okay. Well, that's another one, and this is going to be a fairly repeated theme, and I hate it, but I think this legislation was passed quickly. Department of Labor has weighed in quickly, and there's just lots of gaping holes. That's another gaping hole. So let's say ABC daycare closed down, and that's where my child has always gone, but XYZ daycare across the street is open and available, but mama doesn't feel comfortable with XYZ daycare. There's nothing in the statute that suggests that the employee or the parent is obligated to put their child anywhere that's open. It just simply provides that the child care provider is unavailable, and that would be presumed to be the one that they have typically been using. So I don't know that we can force an employee to go and put their child with a daycare provider if one happens to still be open. I think that's one of those times that we're going to have this liberal interpretation. I think, again, you can have the conversation. We'll have, ask the question. We'll have you, considered other options of daycare so that you can ensure that you continue receiving your full salary and you preserve your FMLA in case you need it later. That's a fair conversation to have. But if they say no, and this is the only place I felt comfortable, then I don't think we can force them. And we would have to say, okay, well, then you meet the eligibility. And that I know is probably not the answer that makes us terribly comfortable as employers. As a parent, I get it, because I know how parents may research childcare providers, and there may be places you don't feel comfortable putting your child. So just the one that happens to be open may not be a suitable option for you. And I don't think there's anything in the law that requires us to force that at this point. Again, I think this is going to continue to unfold, and we'll continue to update through this group if we get new guidance from Department of Labor that fills in the blanks on some of these issues.
Here's another one. When you say cannot telework, is it only if the employee refuses to telework? Example, my golf course manager cannot work from home. His job is completely hands-on, but the county closed the course.
Right. So yeah, so there's going to be situations where there's just not telework available. So if that's the case, then I think they trigger the statute. So it may be a situation where the employee says, I just can't do it because I'm too consumed with this child at home. So I'm making the decision that I cannot dedicate time to teleworking. But more likely than not, it's going to be a situation where the employer, the county, says, we just don't have telework available to give you because you have, you're the golf course manager, or you operate the dump truck, or you do whatever other job that needs you on duty on the job at site. So I think if it's unavailable, either because it's not made available by the employer, or the employee says they can't perform the duties at home through teleworking because of what their obligations are at home, either one of those would trigger and make this available to the employee.
Another question, well, and this is more of a statement, child care facilities will still be affected in the summer if we have these restrictions in place at this time.
Well, that's a great point, because we were focused on school with the last question. So I think as this statute reads, if the child care provider is unavailable due to a public health emergency, then for those minor children that are not in school, or for those children that may not be in daycare during the school year, but maybe they go to child care or daycare centers after school is out, then it could still trigger the act. So that's a great, great point. And I do think it would still be applicable if they're closed based upon the public health emergency and some type of quarantine order.
Here's another one. For school-age children that normally attend summer camp, if the camp is closed for summer due to COVID-19, would the act cover this?
There's no reference at all to camp. of course, what the statute says is if the, and again, I'm going to have it right in front of me, if the school or place of care has been closed, or if the child care provider of such, I'm sorry, let me reread this for you. I'm reading the statute without my glasses, and so y'all forgive me. I'm just going to read it exactly out so we can talk through it from there. The employee is unable to work or telework due to a need for leave to care for the son or daughter under 18 years of age, or such employee if the school or place of care has been closed, or the child care provider of such son or daughter is unavailable due to a public health emergency. So there's that reference to or place of care. And I'm sorry we're working through this together, but that's just where we are. As I said, we're all in this together because it is also new, and these are great questions. So the statute says if the school is closed, or the place of care has been closed, or the child care provider is unavailable, all due to a public health emergency. So that reference to place of care, I guess an employee could argue that, okay, well, the place of care for my child from June 1st through June 15th was YMCA High Harbor Camp, and now that's closed due to the public health emergency. That could apply here. I don't know that that's at all what would have been intended, but I think based on the reading of the statute, place of care is distinguished from school and is distinguished from child care provider. Again, I don't think that's what's intended, but I think if you have that kind of situation present itself in the summer, I think you would need to look closely at considering if there hasn't been any further guidance up until that point that addresses that kind of a situation, that you would need to consider whether to apply that. I don't think it's a clear no. I think it's clearly not the intent. I think that place of care probably is intended to apply to a child care facility, and the child care provider is intended to apply to someone who is providing services perhaps in their home or something short of a daycare provider, because child care provider is defined as a provider who receives compensation for providing child care services on a regular basis. So I think that's intended to be more of a private child care situation, again, versus a place of care being that daycare center. But again, it's not clear. So I think camps would be something to consider if you have that presented to you in the summer. Let's hope we're not still going to be in this place in the summer, but if we are, I would not take it as a hard no.
Let's hope that. So here's another one. If we're creating a form for the employee to complete for COVID related leave and asking for proof of reason and or dependent info, would that suffice for the certification form we usually have them complete for FMLA, or is it in addition to the physician certification for medical reasons only, of course?
Okay, I'm not sure that I totally understood that question.
So, I mean, is the form, yeah, I guess if they're looking for the form they're asking, do they need a form beyond what they're typically using?
Okay, I think you probably do, because your typical forms, if you're using, standard forms that we've recommended, if you were with us on the previous FMLA webinar, which we did not so long ago, we put out forms that are Department of Labor approved. If you're using those types of typical forms, then there's not going to be a box to check that asks these questions that are related to this family medical leave option for child care at home. So I think you are going to need a new form. And remember, again, it's going to be effective from today until the end of the year. So it's a short-term form that would be in operation. But I would recommend having a new form. And I don't think there's going to be a medical certification. I'm not sure what that aspect of the question would be for purposes of family medical leave under this expanded option. But you would have the opportunity to clarify that there is a child, what the child's name and age is, a birth certificate if you wish to ask for that type of corroborating information, a notice of school closure. If it's a private school, I think the governor's order again as to public schools being closed through April 30th should suffice, but I would note that that's the purpose. I think those are the kind of things you need on a form for this EFMLA.
Here's another. If daycares are closed during summer, that usually keeps younger and school-age children. Is that an exception since it's a COVID-related issue?
Okay, yeah, and I think this is similar to the earlier question. I think if the child care provider is unavailable due to a public health emergency, that could still apply in the summer. So those, while this, I think I'm comfortable that if the school is closed, if someone says, okay, I have an 8th grader or a 9th grader and they're home and I need to be home with them to manage their homeschool obligations because school is closed due to the public health emergency. I think that's going to end. That kind of excuse or qualifying reason under FMLA is going to end when school is over for the year. However, for that parent that says, okay, well, my younger child goes from school, but then I transition to childcare or a daycare center in the summertime, if that daycare center is indeed closed due to the public health emergency, then I do think this is triggered. I think that will continue into the summer, not based on school children that don't need daycare, but if it's a parent who would have normally put their child into daycare and that daycare is no longer available, then I think it could be triggered. Now here again, there's so many variables because it has us trusting an employee to say, oh, I normally put my child in daycare. You know, how can we corroborate that? I guess we could ask them to provide us with their registration from the previous summer or, you know, cancel checks from the daycare from the previous summer. I don't know how far you may want to go as an employer down that line if an employee is coming in and asking for FMLA based upon a child care provider not being available during the summer. But I think those types of questions are valid, and you could ask those types of questions. The Department of Labor and its guidance has been clear that we can ask for things to ensure that we are corroborating the request. And they referenced, in fact, having records that are good enough for purposes of the tax credits for private employers. Now, unfortunately, as a local government, we don't get the benefit of the tax credits to the extent that the private employers do, but the Department of Labor references that there needs to be records that are sound enough that can pass muster when you go and try to get that tax credit and reimbursement. So you could think about it in those terms. It probably needs to be something more than just checking a box, but how far you want to go down that road is a policy decision you'll need to make once you, you know, adopt your policies and complete your forms.
Very good.
Jump back
Again,
into the program.
We got 3 more questions, and I'm going to we're going to hold off any questions until you can kind of finish the rest of the presentation. But here's just a few more.
Okay.
If an employee chooses not to work because they are worried about their health and being possibly exposed outside their home and teleworker is not available, do we have them take their leave under this act?
Okay, so that's kind of jumping over into emergency paid sick leave kind of questions. So remember that emergency family medical leave is only for the singular purposes of if you have a child at home. So if it's an employee who's just worried about being out, they want to self-quarantine, they're not comfortable for whatever reason, but they don't fall within any of the qualifying reasons, either for FMLA or under the Paid Sick Leave Act, which we'll get to in just a moment. If they're just voluntarily deciding they don't want to come to work because they're scared and want to protect themselves, then in that instance, none of these leaves are going to be triggered. And again, I'll get to this a little more when I can show you on screen what the reasons are. So if they don't fall within any of the reasons to trigger coverage under this, they have the option to take their accrued PTO. So if they have vacation and paid leave, they should take that. But otherwise, the Georgia Department of Labor has issued an emergency regulation that allows for partial unemployment claims to be filed. There are certain circumstances under which the employer will be required to file those, and I'm going to talk about that in a little bit, but also an option for an employee to file that. And the Department of Labor in the state of Georgia, every state is doing it a little differently because the federal government did pass in this omnibus, Families First bill, a flexibility for all states to handle this unemployment insurance as they see fit. But in Georgia, what they've opted to do is to say, if you're voluntarily not going to work because of reasons related to the coronavirus, but you don't fall within one of the designated reasons to be entitled to stay home or to be entitled to this protective leave, then you can file your own partial unemployment. It doesn't mean you quit your job because you have the intent to return, but you file for a partial unemployment. Now, typically, if you were just deciding not to go to work or you decided to resign, as you know, unemployment would be denied. But in this case, under this emergency order, those voluntary partial unemployment claims will be considered, the department says, on a case-by-case basis, but it's very likely, as they suggested, that it will be granted and it will be determined that that employee is not attending work based upon no cause of their own. That's how they refer to it. So it's very likely they're going to get a partial unemployment if they're voluntarily staying home, but that's independent of these leaves and wouldn't trigger any of these leaves. And I'll try to loop that back in a little more once we get to talking about those sick leave provisions.
So if an employee takes off because their child has asthma and they're afraid of being exposed, exposing that child when they come home from work, does that qualify?
Okay. Again, we're jumping into the sick leave provisions. The sick leave provisions, and I don't want to cheat you out of hearing the rest of this family medical leave, so I may defer and talk about this a little bit more when you can look at the reasons with me up on the screen, but there's 6 reasons under which you can trigger emergency paid sick leave. Remember, it's not FMLA, not what we're talking about now. That's only for childcare. Unless that employee has a advice from a healthcare provider that is advising that employee to self-quarantine, that would trigger the Emergency Paid Sick Leave Act. But if that employee does not have some kind of order from a doctor and is otherwise not under any other kind of federal, state, or local quarantine order, which probably they would not be, in that case, it would be a decision of voluntary quarantine. And for voluntary quarantine, our recommendation to the employee first would be utilize your paid leave. But at that point, and after they've utilized their paid leave, then the filing of a partial unemployment claim would be their responsibility and would likely be granted.
So the next question is a follow-up from a previous question where she asked about the daycare. In this particular situation, the individual, the employee, is at the same daycare. They're not changing. They're just concerned with the daycare they're currently using, that it's not safe. So it's still available. Same daycare is there. They're not closing it. They're just concerned that it's not safe and they don't want to have their child in there. Does that have an effect on that?
Yeah, well, I think then it's a voluntary decision because the act speaks in terms of the child care being closed or unavailable. And so if it's available and still open, I don't think it triggers family medical leave, and it would be a decision for them voluntarily that they wish to be home, and then that would trigger the partial unemployment filing.
Okay. Why don't you go ahead, and we got a couple more questions, but I'll hold those until the end. So just go through the slides.
Okay, and I will answer all of them. I think it may put things in better context if we continue through the program. So back to family medical leave, which again is for that singular purpose of staying home for the child for childcare purposes. Is it paid or unpaid? Well, it's both. And this is a real new twist on family medical leave, which has always been unpaid unless they took their own accrued leave. So the way this works is the first 10 days are unpaid by the employer. So the first 10 days of leave, the county, the city, the government is not obligated to pay anything unless that employee opts for utilizing their emergency paid sick leave, which is automatically going to be triggered because there's a provision, a qualifying reason under the Paid Sick Leave Act that correlates to this family medical leave purpose. So they can either take their 80 hours of emergency paid sick leave, which I think is really the intention of Congress, because they gave you 80 hours and they made these first 10 days unpaid. So obviously that correlates to using that to cover those 10 days unpaid. So that would be what you would anticipate most employees would do. But otherwise, they can elect the emergency leave. They can also elect to use their any accrued PTO or sick leave that they have. Or they can elect to take it unpaid and to save those banks of time. What's very, very clear is that it's absolutely the employee's option. We cannot force them to take that emergency paid leave of 80 hours. We can't force them to take accrued time. For any of you that have, no stacking policies is what I call them, where you may say, okay, for FMLA leave, you're required to take any accrued time concurrently with your FMLA leave. We cannot enforce that with respect to this new EFMLA. You can continue to enforce it if people are going out on traditional FMLA, but for this emergency purposes, the Department of Labor has said we cannot force an employee to use their accrued time. If they wish to take it unpaid for these first 10 days, they can do that. Now, after that, the remainder is paid at 2/3 of the employee's regular rate of pay. And so this is a brave new world. And so this leave can have a substantial impact on the workplace, because these employees obviously are not doing their jobs and they're not at the work site anymore. And yet we're paying 2/3 of their salary. But that's what the new law requires. Now, the first 10 days, I've already addressed this, but here it is on your screen. They can elect the 80 hours. They can elect accrued PTO time, but we can't require them to use either. Now, fortunately, there is a cap. So this helps a lot if you have higher paid employees that may exceed this cap. So on the paid leave, an employee may be paid no more than $200 per day, or no more than $10,000 in the aggregate, and this is per employee. Now, how do you calculate the paid leave? For full-time employees, it's pretty simple. It's their regular rate of pay for the number of hours that they're normally scheduled to work. So that's how you determine it. It does include overtime if that's part of their normal schedule. And so that needs to be taken into account. With respect to part-time or irregular scheduled employees, what you do is you go back and you look at the average number of hours that have been worked for the 6 months leading up to the leave, and you calculate their rate based off those average numbers and the average earnings. If they've been employed for less than 6 months, then at that point you have to go with the employee's reasonable expectation at hiring as to what their normal schedule would be. And basically that means, whatever you discussed with the employee in terms of what their schedule would be if they have not produced 6 months of work to demonstrate what those average hours would result in. Now, the last key point that I want to talk with you about on family medical leave is about job restoration. This is important because we could have a floodgate of people leaving employment of the county and then coming back. So the obligations with respect to restoring that person to the same or equivalent job is the same as under traditional FMLA. So again, to restate, what you would normally have to do under FMLA, you still have to do here, and that is put them back into the same or equivalent position. They cannot be harmed. It's job protected leave. Now, the only exception to that is if you have an employer with less than 25 employees, then they may be excluded from the requirement of job restoration if the position is no longer available due to economic downturn or other circumstances caused by a public health emergency. But it's important to note that for those smaller employers, continued contact for up to a year in an effort to restore the position is required. So you have to stay in contact and put them and give them notice if there's any opportunity for new jobs that may be coming online as the economy improves down the line. So typically, government employers are going to be greater than 25 employees, and that's not going to necessarily implicate this exception. However, if you talked with us when we did the FMLA webinar recently, we had a fairly robust conversation about the notion of these federal cases that have found that these independent elected officials and their offices, if they have less than, under traditional FMLA, the 50 employees, there's federal cases that have considered them separately and found that they don't have eligible employees that warrant FMLA coverage. I think the same could be true here, although of course we have no case law to interpret at this point, but for employers with less than 25 employees in these elected constitutional offices, it could mean that they would be subject to this exception for job restoration purposes. So sometimes you'll have that tax commissioner's office or that clerk of court office where maybe they have 8, 10 employees. If you have a circumstance like that and you have a real issue with job restoration, then you at least need to have on radar that perhaps they could fall within this exception such that they are not obligated to return the employee if these conditions are met, and that is that the position is no longer available. Okay, I mentioned this earlier, but just to restate, intermittent leave is something that can be available for family medical leave. It can also be available for the paid sick leave that we're going to talk about next. This is by employer choice, though. It's not covered expressly in the statute, but the Department of Labor in its guidance has indicated that intermittent leave is available if the employer agrees to provide it. So this is something that I think you really need to consider as you're trying to get your arms around all of this as a policy decision, much like your exception for your emergency responders. This is another one of those big ticket decisions where you need to decide whether you're going to offer intermittent leave. I think intermittent leave can make really good sense, particularly in this emergency family and medical leave context, because they may not be needed full-time at home with the child, or they may be able to telework at home for part of the day and then deal with the child and their schoolwork for the rest of the day. So it's allowed if the employer agrees on it. You need to have a policy and you need to be consistent, and that's really what's important. The Department of Labor has noted a few things, though, in terms of its guidance in this area of intermittent leave. If it is applied and available, teleworking in any increment is available for purposes of this Family Medical Leave Act. So if you're doing, if you have someone that's teleworking and they want to take half the day, say I want to telework 4 hours and then I want to use 4 hours of leave each day, and you're willing to let them do that, then you can do that for any of the qualifying reasons, whether it be family medical leave or whether it be some of the sick leave provisions that we'll talk about as well, because they may be sick or they may be self-quarantined or they may be under a doctor's order for quarantine, but they may still be able to provide some valuable work and to telework for a portion of the day. So any increment for any reason is possible for teleworking. If they're working at the site, intermittent leave is available in any increment, part days or full days, if it's for purposes of family medical leave to stay at home with the child. However, if they're coming into work at the site and they suggest they want intermittent leave in less than a full day increment for one of the other qualifying sick leave reasons, the answer to that is no, because obviously these sick leave reasons that we will talk about in more detail are for purposes of slowing the spread of the illness and protecting the workplace. So we don't want someone suggesting, oh, I want to quarantine myself for part of the day, or I'm symptomatic and I feel like I need to sleep in the mornings, but then I'm going to, blow my nose and come on in the second half of the day. That's not going to fly. So if it's one of those sick leave reasons, it's going to have to be a full day increment for work at home, and really intermittent leave is not going to be very functional in that sense. So I can see an intermittent leave policy for purposes of family medical leave and also for purposes of teleworking, but I can easily see that you might not want to afford employees an opportunity for intermittent leave for sick purposes. Because again, the whole point is to have them out of the workplace for an extended period of time for their protection and the protection of the workplace. So now let's transition to that paid sick leave that we've talked about before. So this one is even more broad in its coverage. There's no minimum work time that's required. Any period of employment will do. So if an employee was hired yesterday and they asked to go on paid sick leave today, it's going to be granted because there's no qualifying length of employment. Also, this statute is actually very clear. There's no question that it applies to all local governments of any size. So definitely you're covered under the Emergency Paid Sick Leave Act. Now, as to exemptions, just like family medical leave, the same exemptions for healthcare providers and emergency responders and the definitions that have been provided by the Department of Labor are indeed the same as well. Again, though, as I mentioned to you, you could make a decision to exempt your emergency responders under one act and not the other, or for certain qualifying reasons and not for others. That would need to be done in a policy for consistency purposes, but I can see a lot of public policy reasons that you might view different qualifying reasons differently for these exemptions, and that's something that you could get creative with to ensure you're protecting your emergency response personnel by allowing them some benefits of these leaves and also getting them out when they're sick and symptomatic, but also to ensure that they're on the job and not allow them perhaps to take leave for some of these other reasons. Okay, let's get to the 6 reasons. So there's 6 big reasons, and only 6, for emergency paid sick leave. The qualifying reasons include the first 3, which I refer to as self-care reasons, and that's because these are employee-based. So the first reason is the employee is subject to a federal, state, or local quarantine or isolation order. So that employee could be sick with COVID-19 and be under order of quarantine for that reason, or they could be under order of quarantine based upon the governor's new order that had some of the more vulnerable populations subject to quarantine, like a patient undergoing cancer treatment. So if they fall within either a federal, state, or a local order of quarantine, then that's going to trigger under this reason number 1. Number 2, the employee has been advised by a healthcare provider to self-quarantine. So in the question earlier about asthma, if that child's doctor issued a medical advisement, and you get a doctor's note signed by the healthcare provider saying, my advice is that this employee must self-quarantine for the sake of the child, then I think it would fall within this reason number 2, that the employee has been advised by a healthcare provider to self-quarantine. The third reason is if the employee is experiencing symptoms or is experiencing the illness and seeking medical diagnosis. So that would be number 3. And I think I left out the word symptoms there, so please forgive that on this PowerPoint. Reason number 3 should be the employee is experiencing symptoms of COVID-19 and seeking medical diagnosis. So we might not know that they are positive. They may not be subject to an isolation order yet, as would be the case in reason number 1, but they're symptomatic and they're seeking diagnosis. So if that's the case, they would trigger one of these self-care reasons. Now, the qualifying reasons continue, going into what I call more care-based reasons. Number 4 is the employee is caring for an individual subject to a federal, state, or local quarantine or isolation order, or has been advised by a healthcare provider to self-quarantine. So again, that parent with the child with asthma could, I think, also fall into number 4 if there's an advice by a healthcare provider to self-quarantine. Now, the employee who's caring for an individual, I've had the question as to whether that individual has to be a family member. And, Congress chose the word individual, and the Department of Labor has interpreted that to mean it does not have to be a family member. So it could be a close friend. It could be, any number of individuals. I guess elderly neighbor who doesn't have someone to care for them. If you're caring for that person, it's an individual. It does not have to be a family member. So that's kind of another twist on what typically would be caregiver status for family medical leave purposes under the traditional FMLA. Number 5, that's your reason basically under the EFMLA. That's when you're home, the employee's caring for the child whose school has displaced them or the child care has displaced them. And then the final reason is just really not in play right now. I think it was a catch-all that Congress has offered up, and that is if the employee is experiencing any other substantially similar condition that's specified by the Secretary of Health and Human Services. I think here the concept is there could be some related illnesses or some variations that come out or some other condition that would lead the Secretary of Health and Human Services to specify new rules. But importantly, number 6 has to be specified by the Secretary of Health and Human Services. There's no such specification of another substantially similar condition. So right now you can take number 6 really off your worry list. Now it's important as to which condition that they request to go out on. And so again, to the extent you're just trying to get your arms around how do you functionally implement this, again, I think this is going to require a new form as well. And I think the form needs to have each of these 6 reasons and have an employee check what reason it is that they wish to be out, and then provide the supporting documentation to support that reason. If it's for their self-care purposes or related to a doctor's order, then obviously having a medical certification or a doctor's order is something we can certainly request and require. If it's related to care for another, I think there would also be an opportunity that you could get medical certification on that care for that other person. Going forward now, duration. How long are they entitled to under this act? So under emergency paid sick leave, full-time employees get a bank of 80 hours. It's important to note that this is a new bank of time. So they could have a ton of bank time under their accrued PTO process, under your employee handbook policies, or they could have none. It doesn't matter. This is a completely new and distinct bank of hours that they're entitled to, and they're entitled to it immediately. It does not accrue. It does not have to build up over time. It is awarded to them immediately as of today, April 1st. So I know for many of you, this is where technology sometimes can be a blessing and a curse. I've had some people say that, oh my gosh, my system, I've got to create some new bank of time and I don't know how to do this with my technology. That is going to be an issue and a struggle. You could wait until someone comes in to ask for it, or you could create that new bank that's out there and available. Either way, it's a separate and independent bank of time for a maximum of 80 hours for full-time employees. Now, for part-time employees, you're going to calculate the number of hours they get equal to the average hours that they've worked over a 2-week period. So if over 2 weeks they work 30 hours, maybe 15 hours each week, then they get 30 hours of emergency paid sick leave in this new bank. So in terms of calculating it, this is why the reasons are important and why you need to be clear that you're designating what the paid sick leave purpose is. So for the reasons 1 to 3 that I referenced as self-care reasons, the employee gets their full rate of pay. So that's like just being out sick like normal, and they'll be paid their full regular rate. If it's for one of the other reasons, 4 through 6, which I call the more care-based reasons, then they get 2/3 of their regular rate. And again, this is for that 80-hour period for full times, or less than that if it's for a part-time employee. Again, we have caps on paid leave, $511 per day and $5,100 if it's for reasons 1 through 3, because they're getting full pay there. It's a lesser rate if they are getting the 2/3 pay for the care-based reasons, number 4 through 6, of $200 per day and $2,000 in the aggregate. So again, it's important to designate what the purpose of the leave is. I've referenced these couple of points. The sick leave is available immediately. It doesn't have to accrue. If you don't use it, it does not carry over. So this bank of time is here for this emergency purpose. And this act will sunset as of December 31, 2020. So if that time is on your books at that point, you just wipe it away. There's no entitlement to it. It does not get carried forward. It's important to know, and I've mentioned this earlier, but it's worth reiterating, an employer cannot require an employee to use their other time first in the hopes that they'll never get to this extra 80 hours. This extra 80 hours moves to the front of the line. So if an employee wants to take it, they're entitled to use it first. They're entitled to use it immediately. Now, it could be used intermittently, like we talked about previously, but they're not required and can't be required to go back and use their accrued time before they dip into this new bank of emergency paid sick leave time. And so that's the second point on this screen, that we can enforce a no stacking policy, can enforce the opportunity for them to use other leave first. And then the last point here is that emergency sick leave does not get paid out on separation. So if for some reason you have an employee that separates from you even now and between this point and December 31st, such that the emergency bank of time is still there and active at their separation, it does not get paid out. This is for the unique and distinct purposes of the emergency. And so if they terminate between now and the end of the year or at any time, they lose the time and it's not required to be paid out. Now, at this point, that really goes through the presentation materials that I had, but I'd like to go a little off script at this point and talk to you about a couple of things that I've mentioned that I think are probably going to be in play and in your mind based upon some of your questions. And that is just going back for a minute about this Georgia Department of Labor unemployment insurance emergency rule. So with respect to that new rule, here's what's important to know. If you decide to send an employee home because you believe they're symptomatic, or you have reason to know that, or they tell you that that they're sick, or for whatever other reason, you just need to reduce hours, you don't have the work for them, or perhaps maybe your county has done some type of a sheltering order and you're sending home non-essential employees. So if that's the case, and they do not have any accrued time, or maybe they do have accrued time, but they've used it, or they trigger the emergency paid sick leave act, but they've used that, and yet the employer has made a decision that's not allowing the employee to come back to work. If it's an employer-driven decision, then under this new Department of Labor emergency rule, the employer has the obligation to file the partial unemployment claim for the employee. And there's some details associated with how that is done. It's to be done online on behalf of full and part-time employees. There's a link that we'll send you after this with a very simple play-by-play of here's how you do it, here's how you log in. This is not something I think typically employers are used to doing, but there is a login directory for employer portals and how to do that, and it walks you through that process. But again, that's only an obligation of the employer if you have caused the leave and they don't otherwise have paid leave to cover their absence. Now, if the employee, and this was one of the questions before, voluntarily decides not to come to work, then in that case, they're left to their own to apply for their partial unemployment, just like would always be the case. But importantly, they're not really unemployed. They're just saying, I'm not coming to work for a period of time. Now, normally, we might say, oh, you're not coming to work. So we call that job abandonment, or we call that quitting. But we wouldn't normally consider that to be something that would be acceptable. In this era, though, if someone is determining voluntarily not to come to work because of corona-based concern, then the Department of Labor is going to construe that as a partial unemployment situation and not a termination. So I would recommend if someone comes to you and says, I'm not comfortable coming to work, unless they give you no reason related, to any of the triggering things that would give them protected leave, and if they have no time to cover, and they may come and say, I wish to resign. If they say that they wish to resign, accept the resignation, and that's great. And I had one county who actually had that happen. Someone said, I'm concerned, I'm not comfortable coming to work. I don't know when I'll ever be comfortable coming to work. And so I know, that you're going to probably not want to hold my job, and I understand. And they characterize that as a resignation. The person did not ask for unemployment, did not ask to stay on or to come back. In fact, gave no promise that they would come back. So you might have situations where employees will resign and they'll just decide, I'm out for now. But if you have an employee who comes and says, I just don't feel comfortable coming now, but I want to come back to my job, then I think you have to tread very carefully with those kinds of employees. I think you need to walk them through the partial unemployment filing that they would be responsible for, but not necessarily terminate them in that instance as a matter of either being, abandonment of the position or any kind of insubordination. If you have a leave of absence policy, you might want to process it through that, just so you have some kind of characterization for it, or you may characterize it now as a new voluntary quarantine under Corona. And I think you could call it that as well. So that's one point I wanted to mention. And then the last point, I think, just to round out the conversation and then open up for questions, would be everybody's really concerned in this new era about, the fact that we're all talking willy-nilly about medical issues. And it is amazing to me that we know, members of the royal family who've had a positive health test for corona, and we know actors and actresses and senators and all these people who've had these medical tests, and they're reporting the results of their medical tests. Well, that's unheard of before we landed in this pandemic, because normally we would be, screeching and crying about HIPAA and concerned about the protection of this health information, but it's become much more widely spoken about. I want to encourage you that any of the documentation that you retain or that you compile related to any of these reasons, that you still protect it in your ordinary course under HIPAA and otherwise as protectable health information. Just because people are talking about it more widely, I think you still need to, within your HR ranks, keep this information confidential, and you still do all the right things, even though our world out there is talking about it on television and otherwise. You still protect what you know and protect the rights of the employees to confidentiality in this information. With respect to whether you're concerned about asking questions that normally you might not feel comfortable asking in the medical world because of the Americans with Disabilities Act, I will tell you that the EEOC has issued some guidance and has made it clear that we can ask questions related to a pandemic crisis. So we can send employees home if they appear symptomatic. We can ask them if they have a fever, if they have a cough, if they have these symptoms of COVID. We can ask them, we can take their temperature, which I have not recommended clients to do because that's deemed to be a medical examination under the ADA. But there's some private employers that are doing that when people come into work in a restaurant or into a store, they're taking their temperature as they come in. The EEOC is saying that's okay. That's a measure that is available in this pandemic situation exclusively. Again, it's going to produce a lot of obligations for confidentiality and protection of the information. So I don't know that that's necessarily something you want to undertake. But the EEOC has given a lot of leeway and guidance here in terms of discussing what otherwise might be deemed some kind of discriminatory request under the ADA to ask about a person's medical status. But if you're asking and keeping it limited to yes and no questions about these symptoms of COVID, also related to even foreign travel, then you can do those things and not worry that you're going to run afoul of the ADA. So you may have more specific questions on any of these things I've just mentioned or all of the topics we've talked about, but I kind of wanted to throw all those last things out to you, even though they're a little off script and off our topics for today, because I think they are so interwoven with these two new federal acts. But with that, that is what I had prepared to share with you today. I know we're a little over our 3 o'clock time, but I'm very available to answer the questions you have for anyone who wants to hold on. For anyone else who may not be able to stay online but may have some questions, remember, if you are an ACCG member county, you're welcome to send those to me through the ACCG helpline, or you can reach out directly to me. My email address is there on the screen, or anyone else for that matter. I'm happy for you to reach out. These are tough times, and as I said, we're all in it together. So happy to help as I can, but also we'll answer any questions for as long as you want to stay online with me now.
So let's go through some of these. We got a few. This is available to PT. I would assume that's a question. I would assume PT means part-time employee.
Okay. I'm sorry, would you restate that question?
It says this is available to PT, question mark.
Oh, yes.
I would assume.
Yes. Yeah, assuming that means part-time, yes. Part-time employees have rights under both of these federal acts as well as the partial unemployment.
Here's a few questions from the same person. And are constitutional officers, elected officials, employees still covered under the paid FMLA leave? And again, next part, to further on that question, some of their offices are smaller and have less than 10 employees.
Yeah, so that was what I mentioned earlier. You know, the exception, there's an exception for restoration of employees if you have the smaller offices, but the application is going to apply irrespective of how many employees you have. So all sizes of offices for FMLA under this expanded purpose only. Now, remember, we're not upsetting the apple cart for general FMLA, just for this expanded purpose, as well as emergency paid sick leave, no matter what the size of your government office is, it's going to apply. The only exception for less than 25 employees is going to be that exception that I mentioned with respect to the obligation to restore the employee to their position. That if the position is no longer available, then you could be exempt from that requirement. But otherwise, you have to give the leave, you have to pay the leave, but there could be an exception to restoring them to the position.
So I got a question. We have an employee went off for number 2 last week. This doesn't start until today. What happens?
Okay, that's a good question, and it's difficult because this is probably going to be more of an answer than you want, but I'm going to give it all to you. So the act itself specified that that compliance must occur no later than I think it said 15 days after enactment, which actually would be April 2nd. The Department of Labor took that and for whatever reason determined that April 1st would be the start date. I was looking here to see if I could find the exact language, but I can't. But that's what it said. So by it stating that it should be in effect no later than, there's many people that have had the question about, you know, pre-compliance. Well, okay, if we have to be doing it no later than April 1st or 2nd, can't we go ahead and start because we have employees in need who are taking these leaves or need to take leaves right now? And here's, I'm sorry, I found the language. So it says the act shall take effect no later than 15 days after the date of enactment of this act. So based upon that language, while we were in sort of this interim period, there were, you know, a lot of clients, and it may be the person who asked this question in the same boat, who felt like, okay, well, we have to comply by this date, but we're going to go ahead and start complying because of the way the act reads and because I have employees who need the leave now. Well, the Department of Labor, when they issued their guidance late on Friday, and then some more questions were released on Sunday evening, they said and made clear that the act is not retroactive, meaning that it's effective on April 1st. And so any time taken up until April 1st will not be recognized under the act. So unfortunately, if those employees did not have other accrued leave to take, they needed to do that or to be unpaid, or if you paid them, you know, mistakenly, there's not going to be the ability to count that against the 80 hours of emergency paid sick leave or to count those days against their 12 weeks under the EFMLA if that was the purpose for their absence from work. So unfortunately, the Department of Labor guidance, which doesn't quite square up entirely with the federal legislation, would say that April 1st is the beginning, the only beginning. Anything that happened before April 1st is not going to count or be available to you. Now, where that could matter, again, is more importantly probably for private employers who could have tax credit benefits. But for the county, I think if an employee said, wait a minute, I may have taken 20 hours on March 30th, or you know, between March 25th and March 30th, but now I still get 80 more. And I think the answer to that is yes, that's exactly right. They're going to be entitled to that.
Okay. Here's I think a good question. Just curious, would LGRMS or ACCG possibly help with the forms and policies? I know that in the past have adapted policies that were provided as guidance for local governments to use.
That's probably a Dan Beck question. Dan hasn't asked me to write a policy yet. And interestingly, I haven't had a client ask me yet to write a policy. I think it's because we've all been just clamoring to get our arms around what it means and what our options are so folks can determine what they want that policy to say. because there are some variables here, you know, for several of the issues that you need to determine as a matter of policy. The form, I think, is much more clear cut. I haven't developed anything yet, but I anticipate that we will be doing that, and I'm certainly happy to share those once that I do, and I will circulate that through Dan if, you know, he can share that. But I don't have anything currently, or I would push it out immediately. It's all been rolling down the hill quickly, but I think we're getting our arms around it now that the effective date is here, and so that'll be step 2. I'm happy to share when we do that.
I would ask anybody if anyone has a policy or form that they'd like to share, just send it to me, and we'll probably let Angel take a peek of it before we ship it out. But again, a lot of good best practices out there. Here's another question. How soon does an employee need to file the emergency sick leave, such as the department head sends an employee home due to symptoms?
So if I'm understanding the question right, if a department head observes somebody sick and they say, go home, then I think the department head needs to, you know, probably be responsible for communicating that to HR. And I would say HR, take the initiative. You know, if the employee's been sent home, at this point, especially if it happens in the near future, I hope you have your poster up. You know, the Department of Labor has put this out. I don't know if you can see what I'm holding up, but this is the proposed notice poster. It doesn't have to be this exactly, but my recommendation is always just use what they put out. So this should be posted as of today, along with all of your other posters. But an employee that gets sent home today, or maybe that's already been sent home, you know, say they got sent home yesterday or last week, they are not going to be there to see these posters. They may not know that they have these rights. So I think HR needs to take the initiative to reach out to those people already home, or those people who get home, sent home immediately, to let them know of this opportunity. So it may end up that they're not going to know when they get sent home with a sniffle, or more importantly, you're probably not going to want them then to come into your office if we believe they're symptomatic and being sent home for quarantine purposes. You're not going to want them to show up at your door and to pick up your pen and fill out your forms. You're probably going to want to do that remotely or through telephone. So those are going to be some logistics that you'll need to work out in terms of, you know, how your company, or I'm sorry, your government functions. But I would like to see the department head report that, HR then make the contact, and HR take the initiative to make contact with those employees who may be currently sitting at home on quarantine purposes, if these federal laws are triggered, to give them the options and their rights.
Here's another question. So under FMLA, the employer has to use their personal leave if the county/city orders non-essential people home instead of unemployment.
I'm not sure that I understood that question. Can you read that again?
So under the FMLA, the employee has to use their personal leave if the county/city orders non-essential people home instead of unemployment.
Okay, so if they're ordered home, that's not going to trigger EFMLA at all, because EFMLA only deals with the caring for the child. So if you've been ordered home because of being a non-essential employee, then I would say, you know, if you look at the sick leave purposes, you could say that the employee is subject to a local quarantine or isolation order related to COVID-19, possibly. It would depend on, I guess, how the county determined to send those employees home. Are they doing it? You know, and a lot would matter about how the resolution read. Did the resolution read that they're being sent home for separation purposes, for quarantine purposes? I would assume that's the case, as opposed to being sent home because it's a shortage of work. If there's just reduced hours, which is more of a, you know, typically a private employer thing, if there's a reduced hour situation, or lack of work situation, or a layoff situation, then that's not going to trigger the emergency sick leave, unless they have, yeah, that's really not. It's not going to trigger sick leave. It's going to trigger that unemployment opportunity. But if the employer's sending them home, then the employer's got to file for the partial unemployment. But if they've been quarantined or sent home as a matter of a sheltering ordinance, which I think is typically going to be the case when these non-essentials have been sent home because it's a part of the county's overall sheltering ordinance in the county, then that would constitute a local order under that number 1. And that would mean the employee could get the first 80 hours of paid leave. Now, beyond that, then once their leave has expired, the employer would need to file for that partial unemployment. It's important to note that they cannot get partial unemployment while they're still receiving any type of paid leave.
Okay. While the employee is receiving unemployment, the employee has obligations for his or her insurance deductions that have not been met. So I think that's asking regarding if you're getting benefits, if you're still have to pay for the insurance, your health insurance and other things.
Right. So, you know, there's, of course, there's no specific guidance on that in the federal law or from Department of Labor at this point. My recommendation is that you would treat it exactly like you treat under FMLA. And actually, with respect to the FMLA, I believe the Department of Labor did address health insurance and said it would be applied the same way as FMLA. Yes, it does. So the Department of Labor, in their guidance question number 30, asked about whether group health insurance should be continued while someone is out on EFMLA. And the answer is yes, but you can also require them to pay their premiums just like you would do under traditional FMLA. So you would treat it just the same. You know, on the paid sick leave, that's just for 80 hours. So presumably there's not going to be a big health insurance issue from a coverage standpoint on that. But the health insurance, I would say, continue to make it available, but they do need to continue to pay their premiums. If they don't do that, then I think you're going to have to address it just like you would do under any other circumstance where the employee is out on leave or out on short-term disability or out on a leave of absence and they're, you know, in default on their obligations, and it could end up being a COBRA situation if that were to occur.
Very good. Scenario: employees' daycare closes. They find a relative to keep their kids in the meantime. Afterwards, their child care provider reopens. Now put my glasses on. Now the employee doesn't wish to utilize them, but wants to use the relative instead, but the relative can only keep them for 3 days a week. Can we require them to utilize their former child care provider that temporarily closed, but now open and unavailable instead of granting EFMLA?
Well, that's a tough one. You know, that's a tough one because, you know, as you know, it's just not directly covered. So my best advice on that, I mean, I think if you're strictly reviewing the statute says if the child care provider is no longer available, well, now it's available. And I think it's a different situation than if you are just trying to suggest that you just need to go across the street and use someone else. This is a child care provider that the family used and felt was appropriate previous to any of these issues. So, you know, I think it would be reasonable in that instance to press back and to say, no, you know, here's what the act says, child care provider is available now. So we believe you need to, you know, put your child back into that daycare, or at least for those 2 days. If you want the relative to keep them for 3 days, then that child care is available for 2 days. You know, at the end of the day, again, you know, this has been put out and emphasized through Department of Labor and the other enforcement agencies for employers to be flexible, for this to be liberally interpreted to help employees. But in my mind, that's pushing it a little bit far. And I think it would be reasonable to you know, to push back on that. Now, are you going to outright deny it if the employee insists? You know, just know that when you deny it, if they were to make a claim, the enforcement under the EFMLA, like FMLA, is consistent with the Fair Labor Standards Act enforcement, which is, you know, available damages and liquidated damages and all those things, and attorney's fees. And so, you know, the risk of denying coverage and getting it wrong is significant. but also we've got to make, tough calls when they're appropriate. And this one to me sounds like a bit of a stretch, just to decide that, oh, I don't want to go to that provider anymore. That seems like an issue that's not contemplated through these protections.
Very good. Did she say recommends not to take temp of employees before letting them back to work?
I'd said that I wasn't crazy about it and that I haven't recommended it as just a best practices. I think, each county or city has to make their own decisions on how they want to protect their workplace. There's the more moderate approaches where there's sanitation stations everywhere and there's hand washing everywhere and there's, cleaning crews that are wiping down every hour and all of those things that are easy to do. I don't know of a county or a city that currently is taking temperatures of employees as they report to work. I know some private employers I mentioned, I know that are doing that. The EEOC has made clear that they're not going to deem that to be an inappropriate discrimination based on disability. So I think you can do it if you want to. My only concern about it, and the reason I say I'm not crazy about it, is just simply because I think you need to ensure that you have a protected area so that you're not invading people's privacy, so that you could do it privately so that the reading would not be observed by others, ideally. Excuse me. And I think that you would need to, obviously protect that health information like you would any other protectable health information. So it's just a burden to put on your organization to do it.
Okay. God bless you. Can our county decide that they do not want to allow employees to be able to supplement the 2/3 with current leave balances?
Forgive me, I really think I have a frog in my throat, but it just makes me nervous to cough anymore.
I know. Good thing you're not in Walmart or Lowe's.
I know. So people will be sweeping in to remove me. I really think I just have a dry throat from talking so much, so I apologize. Yes, I think your county, your city could say we're not going to allow the ability to supplement. That is certainly provided as an option to you. The Department of Labor in its guidance has made clear that that's an employee allowance, that the employee cannot demand the ability to supplement. The only thing I'll say about that is you may want to. And the reason I say that is typically, employers have these no stacking policies and concurrent leave policies because we want people to burn up their time and not be able to take, 12 weeks of FMLA and then take their 2 weeks of vacation and then they've got, 40 more hours of sick leave and then they stack it all up until they're out for, months. So in my mind, I can see that it could be desirable to say, oh, sure, we'll let you take that other 1/3 of pay while you're on FMLA through your sick leave time, because that's reducing their bank. And that means they won't have that extra time to take later. And so that, that's just a decision to make for your organization, but you are at liberty to make that decision not to allow the supplementation, just like you can decide not to allow intermittent leave. Those are completely employer-driven decisions at this point.
Okay, here's a question for, can the emergency paid sick leave be used intermittently in the case of caring for a child whose care facility is unavailable? Example, an employee typically works 80 hours in 2 weeks, but can work some days. Can we spread the 80 hours of paid sick leave over 3 weeks?
Yes, if you choose to. Again, it's an employer-driven decision. You're not mandated by law to do it. I think the intermittent leave works particularly well for childcare situations because, the parent probably doesn't need to be with the employee for 8 hours. I'm sorry, to be with the child for 8 hours. They may need to be home for 4 hours, or they may be able to share duties with their spouse. So I think it works well in the EFMLA context in particular, or for any purposes for caring for someone. As I mentioned earlier, I don't think it works well when we are sending them home for symptoms, obviously, or for sickness, because the ideal there is you need to be out of the workplace and you need to be quarantined, so coming in and out doesn't make sense. But I do think it makes sense, and it's available. It's not required.
Is again, that you just have to be consistent when you offer it for some employees with all employees, correct?
Absolutely, absolutely. It needs to be everybody treated the same, and I would encourage you, as one of your first steps as you decide how you're moving forward, that you make a decision on the intermittent. You make a decision on whether they'll be permitted to supplement these leaves with their own accrued time, and you make a decision on your emergency responders. I think those are the big three things that you need to make a policy decision on how you intend to handle those, because you're going to get that question, and then once you make the first decision, you need to be prepared that that's the policy that you intend to carry throughout to be consistent.
Okay, here's another kind of similar question that you answered previously. Can you or ACCG provide a copy of the newly developed FMLA forms that we need to use during this time period?
Yeah,
and I think we'll talk about that later.
Yeah, so the Department of Labor has not promulgated forms yet. Hopefully they will, but I mean, everything's moving so fast, and almost by the time, they go through their rulemaking, they say also they're going to issue regulations. There's a big rulemaking process. By the time they go through the process, we may be out of the height of this crisis. At least I pray that we will be. So we don't have any official Department of Labor approved forms, but that's something that I think Dan and I will talk about us working on, and certainly be willing to share with you when we create something. Currently, there's not a template at this point.
Where are we to get the employee information posters?
Okay, I believe those were sent out to a lot of organizations through the Department of Labor. If not, you can go on the Department of Labor's website, and that's dol.gov/agencies/WHD. And you should be able to find a copy of it there, and you can just click and download it right from there. It's the Wage and Hour Division of the United States Department of Labor. So if you had trouble getting that that link that I just read off, if you just go to Department of Labor Wage and Hour Division, you should be able easily to find the notice poster. If you have any trouble with that, reach out to me individually and I can send it to you. Or I believe we could even send it out with this information, right, Dan?
Yep, definitely. We'll send it out with this information.
So. Okay, I'm sorry. Let's make it easy. We'll send it out.
Yep. Very good. Last question. My county closed buildings to the public March 18th, and we still are. At the time, we placed all non-essential employees in and on call status, and we're paying them 40 hours per week and calling it admin pay. If we continue this as long as we can afford to, we do not need to deal with the unemployment or sick leave, right?
Yeah, I think the answer to that is yes. I mean, if they're able to be home and they're on full-time pay, then there would be no entitlement because there would be no reason for leave.
Very good. Well, I'd like to thank everybody that participated, everybody that asked a question. Lots and lots of questions. Thank you so much, Angela. You knocked it out of the ballpark again. Great webinar. I will, as I said before, I'll be sending out the poster. I'll be sending out a copy of the presentation, the summary form, and the webinar recording, and we'll be working on some forms and some other things for folks. So thank everybody so much. Have a safe and healthy rest of the day. Anything you'd like to say, Angela, before we take off?
No, just thank everyone for participating. You asked so many really, really great questions that will just spark, additional development of materials for me, and I appreciate it, because hearing from people in the trenches and individual fact patterns that you're experiencing is always so very helpful. And so we will get to work on forms and policies and hope that we can share those with you in the near future. And as Dan said, these other materials will be coming out immediately. But just thank you, and just best of luck to you. I hope you stay well, you and your work families and your home families, and that we all get through it together. Thanks.
Thank you. Thank you so much. We'll talk to you later.
Thanks.